everyone. Welcome to today's immigration chat. I am attorney Lillian Chukura. I am an immigration lawyer based in Worcester, Massachusetts, and I help my clients get status for themselves and for their families using the U.S. immigration system. Today, I want to talk to you about stepchildren and children filing for them. All the questions that I've received so far from the last video I did on stepchildren, going through all those questions and taking your questions live. So if you are joining me, know that you can ask me your questions in the comments and I will be responding to you. If you have any questions about this or anything else immigration related, you can book a time to talk to me over Zoom or in person by going to lilylegal.com or by calling my office at 508-443-1788. So now that we got that out of the way, let's get into today's topic. I am so excited about this. A lot of people ask me about filing for their children, their stepchildren. Either they just got status or they're married to someone that is a US citizen. So they want to know what their options are. So I did a whole video on filing for stepchildren. And today I want to respond to the questions that I received after that video. I received a lot of questions after doing that live. So I want to go through and answer those questions for you and also take your questions live. So if you have questions, put them in the comments. If you are watching this on a replay and you have questions, go ahead and put it in the comments. I always go back and respond. And if I get a lot of questions, I'll do another one of these videos where I respond to the questions so that you can get all your answers in one place. Okay? So if you are joining me, feel free to say hi in the comments. Tell me where you're joining me from. Let's get this chat started. Okay? So I'm going to go through these questions in the order I received them, not, you know, not in any particular stop topic or anything like that, just in the order I received them, because some of you might have the same questions and not sure how to ask. So let's go ahead and go through these. So the first question is I'm going to read it. It says, I want to petition for my husband and my stepchildren. We just had our 3-year anniversary. We're holding our filing due to financial circumstances during the pandemic. I would like to ask if I should file for all of them at the same time, or if I can petition for my stepchildren first and husband after, or vice versa. He hasn't been able to see them in over 8 years, and I just want us to be a big happy family. She's heartbroken that the process takes so long. So yeah, let's get into that question. That's a very common situation for a lot of people that have been separated from their family members for so long. Me personally, I was separated from my dad for about 6 years. So he was in the US, I was living in Nigeria with my mom and my sister. So I understand the need and the want to basically have your kids with you and go through this whole immigration process as quickly and as swiftly as possible. Okay. So, first thing is, she asks if she can file for all of them at the same time. And the short answer is yes, right? You're really only limited by your financial abilities when it comes to how many people you can file for at the same time. So if you have the financial ability to file for all, for your husband and your stepchildren, and they meet the requirements of stepchildren, you are able to file for them at the same time. Again, the limit is basically your financial ability to pay for the filing fees. If you're using an attorney, to pay the attorney's fees, to basically go through that whole process. Another thing to keep in mind is that you would need to have the financial ability to support your household. right? So for each application, you have to show that your income is sufficient for your household. So if you file for your husband first and your husband gets their green card, and now you want to file for your stepchildren, your household is a household of two. If you're filing for them at the same time, your household is you, and whoever you're filing for is considered separate applications for each person. So you're only showing your income for the person that hasn't received their green card yet, and not for the whole, not for all your stepchildren and your husband. Okay. So that's something to keep in mind. That's really the biggest thing. Now, now let's get into the real question, right? She has been the husband has been separated from the kids for over 8 years. Now the husband has to decide what's more important, being having the children come and then him getting status. Again, if finances is an issue, it might be financially better for them to file for the kids to come, just to stop that family separation first, and then file for the husband. Okay, so that's something to also keep in mind, is that sometimes people are not filing for their kids not because they don't want to, but because of the financial requirements of going through the immigration law system. It is a whole system. Every single form has a filing fee. And the system is so complex that most people need a lawyer to help them, guide them through that process. So when you're thinking about the fees involved, you're not just looking at the filing fees. You should also be having a budget for the filing fees and the attorney fees, so that when you are going through that process, you have a reasonable expectation of what that whole thing will cost you. Okay. So it is extremely important that when the choice is between um, being separated longer and having the kids here, is just figuring out, um, because you can always file for your husband that's here. But if the family separation is really your biggest thing, then go with the kids first and then your husband. But again, if finances is not an issue, you can file for the kids and the husband all at the same time. So that's something that I wanted to cover, because family separation is something that is huge in the immigrant community. Some people come here and they have not been back home for, you know, decades. Right? They haven't seen their children for decades. So having a way to not just file for yourself to get status, but for your children to get status through your now US citizen spouse, is something that is great. And I always love giving people that option of, not only can you get status through your US citizen spouse, but if you got married before your children turned 18, they are now automatically the stepchildren of a US citizen, and they're considered a child of a US citizen. So, therefore, the US citizen spouse can file for the children. So, it's one of those things that people don't even think about when they are getting into the whole immigration journey of, I'm married to a US citizen, I'm going to get status, and then I'm going to file for my kids once I get my green card. But that's only one way of going through that process. So another way is what I'm suggesting, which is your spouse can file for you, and if your kids qualify as your spouse's stepchildren, your spouse can file for them as well, all at the same time. Okay. So that way you're not waiting for you to get a green card and then waiting for the process to go through for the kids. Under your green card status, you are able to not only get status, but already have an application in place for your children to then join you, or for your children to get status. So it's really important to know that that option exists and how that would work in your particular situation. Now, the next question. My mom married a US citizen when my sister was 17 years and 5 months old. but she is now 21. Can my mom's husband still petition for my sister as his stepchild because they got married when she was still 17? That's a great question. Okay. So once the marriage took place while the child is under 18, they are automatically stepchildren forever. It doesn't matter if they later on turn 21, they are considered stepchildren for immigration purposes. Okay. Now that they're considered stepchildren, the same rules that apply for children apply for stepchildren. Okay. So remember, for children, a US citizen can file for their children that are under 21, children that are over 21, and children that are married. Okay. So in this situation, even though she's already over 21, because the marriage took place before she turned 18, the the stepfather can still file for her. It will just be a different category. She will now be in the category of um, over 21, right? A child of a US citizen that's over 21. So she'll have to wait for a visa to become available for her to get a green card. However, it is still possible for her to get the green card through the stepfather, even though she is now 21. The key here for step parent stepchild relationship is that the marriage took place before the child turned 18. Okay, that's really the key. If the marriage takes place one day after the child turns 18 or the day the child turns 18, the step parent stepchild relationship is not created. Okay, so that's really, unfortunately, that's a problem, right? That makes it harder for people to get status through family. However, if the marriage, like I said before, if the marriage takes place before the child turns 18, they are automatically stepchildren of the US citizen or permanent resident. And the same rules that apply for children apply to stepchildren. Okay. So the next question is basically a follow up to that. Is so now, would she get immediate relative status even if she's now 21? So that's the other part of it, right? So children that are under 21 are considered immediate relatives of US citizens. Once you're over 21, you are now in a preference category. You have to wait for a visa to become available. Immediate relatives have a visa immediately available to them. It's just the time you're waiting is just how long is it going to take the immigration office to process your application and get you in line for an interview, right? But someone in a preference category, there's only so many visas available in a year for each preference category. So if you are over 21 and your parent is filing for you, you are in a preference category. Okay. It might take you 5 years, 5 to 6 years for a visa to become available. So even though you are the child of a US citizen, it can still take time for a visa to become available. And once a visa is available, then you can file to get your green card. So it's a process, and turning 21 definitely takes the person out of the immediate relative. Um, and getting married. So turning 21 and getting married turns someone from an immediate relative to a preference category. Okay. And that getting married means even if you're under 21 and you're getting married, you are no longer considered quote unquote child, right? So you're no longer considered an immediate relative. So that is something to keep in mind when you're filing for your children. Is that if they get married while the process is going, it's most likely going to take them much, much longer to get to the US. Okay. Again, not telling people not to get married, but you should know what that means for your situation before you decide to get married, instead of waiting for the visa to become available or waiting for your application to be processed. All right. So, next question. So, this question says, Lily, I live in Washington and my wife is from the Philippines. We were married in April of 2019. My wife has a daughter still living in the Philippines who is 16 years old. We want to sponsor her to come here to live with us. Is my wife the one who should fill out the form I-130 or me? My wife is not a US citizen but does have a green card. I am a US citizen. It seems to me my wife should be the one filling out the form. Is that correct? So, again, this is what I talked about before, that when you're filing for a stepchild of a US citizen, right, there is two routes that you can take, right? If you're married to a US citizen and you have a green card and your child qualifies as a stepchild, but they're outside of the US, there's two routes you can take. You can file for them as a green card holder, filing for a child, or you can have your US citizen spouse file for them as a step parent. If they're still under 21 when this happens, they're considered immediate relatives and their application is going to be quicker. So it really depends on which how long you're willing to wait and when and how old the child is. Right. So the younger, if the child is still under 21, I generally recommend that the US citizen spouse files as the step parent because that just makes them an immediate relative of a US citizen. They do get um some preferences. So right now with the embassies being closed, so I'll tell you kind of what sort of preferences I mean. With the embassies being closed and some of them only taking on limited amount of cases, priority is given to immediate relatives of US citizens. Okay? Priority is given to immediate relatives of US citizens. So if you were making the decision, let's say a year or two ago, on whether you, the green card holder, should file for the kids or your spouse as a US citizen should file, if you filed, it's going to take longer for you to get the interview now that the embassies are doing limited interviews because you're not a US citizen. Your child is not an immediate relative of a US citizen, right? That's not the application that was filed. It was a child under 21 of a lawful permanent resident. Okay. But if your husband that was the US citizen filed for the stepchild, they are considered immediate relatives and they will get priority when it's time to schedule interviews. So it's really important to know that there is some benefits to having the US citizen file for the children versus you waiting till you get status. Okay. Now, if you are in a situation where you are in an abusive relationship and you do not want your um, spouse, even though they're a US citizen and they qualify as a step parent, to be involved in your child's process, then I would suggest that you, the permanent resident, file for your child on your own without involving your abusive spouse. Okay. Those are the situations that I would not recommend filing with your spouse, or having your spouse file for your child. If you are in an abusive relationship, that's not a healthy situation to bring a child into. So you really want to make sure that you are the one filing and controlling the process because, again, power and control in abusive relationships. This is something major. Filing for a child to come to the US is major. So that's definitely something that's going to be a source of control. So you definitely want to make sure that you are protecting yourself and your child as you're going through that process. Okay, the next question. My mom and my stepdad got married when I was 12 years old. My question is, can my stepdad petition me even if I'm already 25 years old now? Again, that's like the previous question. And the answer, as you all should know by now, is yes. They can still, the stepdad can still petition because the step parent stepchild relationship was created before the child turned 18. Now, again, they'll be in a preference category. They are no longer immediate relatives, so it's going to take some time for a visa to become available. But definitely, the step dad can petition for the child. Next question. Can my stepmom petition for me? I'm 18 years old, but my dad and my stepmom married when I was around 10 years old in the Philippines. Again, you all should know the answer by now. Yes, and because she's 18 years old now, she's considered an immediate relative of a US citizen, so the application is going to be faster than if she was already over 21. So she's in a different situation than the previous person, than the previous people, because the application is going to go in before she turns 21, and she will be considered an immediate relative of a US citizen. Um and that is major for most people because it shortens the amount of time that you're spent away from your family, and it gives you benefits that other people might not. So an example of a benefit that you get with immediate relatives is that if you came in, for example, you came into the US with a visa and you overstayed, whether you were 10 at the time that you came in and you overstayed, but your mom or your dad married a US citizen before you turned 18. Now you're 18 and you want your stepdad or your stepmom that's a US citizen to file for you. Because you're now an immediate relative, guess what? Guess what? You don't have to leave the US to complete the process. So that's a huge benefit to being an immediate relative of a US citizen, is that it waives the fact that you overstayed your visa. Okay. Immediate relatives of US citizens don't have to worry about the fact that they overstayed a visa, because the fact that the person filing for you is a US citizen and you are an immediate relative of a US citizen, your overstay is waived. And if you worked without authorization, that work is waived. Other people, so once you get into a preference category, it's not waived. Okay. It's a problem. You will need a waiver. But for immediate relatives of US citizens, it is automatically waived. Okay. So that is something, again, to consider when you're trying to decide between the permanent resident parent versus the US citizen step parent filing for the person, especially if the person is in the US. If the person is not in the US, it's just about the how long it's going to take. If they're in the US and they overstay the visa, or they work without authorization, being an immediate relative is beneficial. Okay. Um, so here's the other question. What happens when the child is 18 before the marriage? Okay. While the mother has a green card, can she file for her 19-year-old child? Okay, so this is a little different. The marriage took place after the person was already 18, and now they're 19. Um, yeah, so now they're 19 and they want to know if their mother, that is a green card holder, can file for them. And the answer is yes. So green card holders can file for their children that are under 21, their children that are over 21, their spouse, and that's it. They cannot file for married children. So in this situation, my advice would be, sure, your mother can file for you, because generally a green card holder can file for their children that are under 21 and you are under 21, right? Check that box. Now the question becomes, if you get married while the process is going, your application is going to be kicked out, because guess what? Permanent residents, green card holders, cannot file for their married children. So if you, the um the child, get married before, okay, if the child gets married before the green card holder becomes a US citizen, the application is thrown out and you have to start over. However, if the child gets married after the green card holder gets their citizenship, in the US, it's fine. It will just change categories. But if they get married before the green card holder becomes a citizen, the application is completely thrown out and you have to start all over again. You can't recapture the that time that you that the application was pending. You just have to start over. Okay? So it's really important to keep that in mind. And if you are for example, if a US citizen is filing for a child and the child gets married, it's a different category. So it's going to move you from unmarried child of a US citizen to married child of a US citizen. Whether you are over 21 or under 21, it does not matter. Once you get married, you're now in the category of married child of a US citizen, which is going to take longer than an unmarried child of a US citizen. Okay? So that is that. And then the final question that I have on my list is, can I apply for a US passport for my stepchild outside the US? Okay. So this is a tricky question if you don't understand how US passports work. So when you are a US citizen in the US and you have a child abroad, you can apply for them to get a passport at the embassy. However, however, when it is a stepchild, you don't get the same privileges, right? You can't just go and apply for a passport for a stepchild. You have to go through the immigration process of filing for the stepchild, and going through the interview process at the embassy for the stepchild. Once they get to the US and become a green card holder, right? Once they're a green card holder, they have to wait the 5 years to get their citizenship. Unless, of course, they're able to derive citizenship from their mother or their father. Okay. But as a step parent, you cannot automatically go ahead and file for a passport because they don't qualify. The stepchild does not qualify to automatically get a US passport unless they are able to derive citizenship from their actual birth parents. Okay. As a step parent, you can, like I said, you can go through the immigration process of filing an I-130 and then doing a DS-260 with the embassy, and then having the stepchild go to the interview, come into the US, get their green card, wait the 5 years, and get their citizenship. Okay. Again, for citizenship, I say 5 years. However, if the child is, let's say, 10 years old, right, and they come in when they're 10 years old and they're applying for citizenship on their own, they're applying for naturalization on their own, they have to wait till they're 18. So that's something to keep in mind, is that although the child is coming here as a green card holder and you're a US citizen as the step parent, unless the parent is also a US citizen and meets the requirements, the child does not automatically become a US citizen. The child will have to wait till they're 18 years old to file for citizenship, unless they automatically acquired citizenship from their birth parents. Okay, so those are the questions I had in my inbox about step parent relationships. Again, just to make sure you understand what that is, it's when a US citizen, right, it's when the marriage between a birth parent and a step parent take place before the child turns 18. So as long as the marriage took place before the child turns 18, that step parent relationship is created. Again, the marriage that creates that step parent relationship has to take place before the child turns 18. Once the child turns 18, even though you're technically a step parent, right? Uh, you are not able to give the child immigration status based on that step parent relationship. That's something to really keep in mind here. So just because you get married to someone and you consider someone your stepchild doesn't always mean that immigration will consider them your stepchild. The requirement is that the marriage that creates that relationship has to have happened before the child turns 18. Again, this is, if it's 10 days before the child turns 18, it's still fine because they're not 18 yet. Okay? If it's 1 day before the child turns 18, it's still fine. They're not 18 yet. If it's the day of their birthday, the day they turn 18, and you get married on that date, that step-parent stepchild relationship might exist in your heart, but not for immigration purposes. It's really, really important that I stress that, because I have a lot of people that think that just because they married the person and they consider this person their stepchild, okay, if you got married and the person is already, 25, no, they don't qualify for the stepchild, step-parent relationship for immigration purposes. Again, in your heart, that's your stepchild, that's your child, it's fine. Okay, but for immigration purposes, unfortunately, it is not. Okay, so if you are just joining me, feel free to ask me questions in the comments. And I just want to say hi to everyone that's here and commenting. Hi, Faith. Thank you so much for joining from Massachusetts, as always. Thank you. And then Miss Elaine, hi there. Thank you for joining. And then Leona, thank you so much for joining me. And then Sa, thank you. I'm glad you find this topic, this discussion helpful. If you have questions, go ahead and put them in the comments. I'm here to basically answer your question. Hi, Bayan. Welcome. I'm so glad to see you. And as you guys all know, I'm here every Friday at 12 p.m. Eastern Standard Time to answer your questions. So it can be about this topic or it can be about any other immigration topic that you have questions about. As always, I can give you information about your question. I cannot give you legal advice because I need to know more about your personal situation before I can legally give you any legal advice. You like that? So just know that you can leave comments with your questions. And if you're watching this on the replay, hi, welcome. Put your question in the comments as well. I do go back and I respond to you. And if I get enough questions, I do a whole video responding to those questions. Okay. So, and as always, like I said, put your questions in the comments. I'm here for you every Friday. Every Friday, I'm here to answer your questions, to basically chat with you about all things immigration. This is all I do is immigration law at my firm. So I love talking about it. I love answering your questions, and I just love giving information to all of you. So go ahead and put your questions in there. If I don't see it, I will come back and respond in the comments. Okay. So don't feel like you can't ask me questions after the live is over. Now, if you would like to meet with me personally, you can do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. You can also send us a WhatsApp message at that number requesting a consultation. Okay, so that is all I have for you today. Thank you so much for your time. And remember, if you like this video, go ahead and hit the like button. Okay, if you know someone who needs to hear this, please go ahead and share it with them. And if you are listening in a place that you can subscribe, like my YouTube channel, go ahead and subscribe so that you don't miss anything that I upload. Okay. And once again, I am Lillian Chukura. I am the owner and attorney at Lily Legal, and we do immigration law, and we help families come together using the US immigration law system. Thank you so much, and I will see you, as always, I will see you next week, Friday, same time, 12 p.m. Eastern Standard Time. Bye for now.